Thank you for attending Up in the Air, Residency Requirements in Cannabis Licensing, hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law in the Parabola Center. Before we begin, we have just a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Second, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time. However, please note that there is limited time available for Q&A at the end of the presentation. Third, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Doug?
Thank you, Holly, and thank you so much to everybody for joining us. I'm Doug Berman. I'm the director of the Drug Enforcement and Policy Center, and I'm extraordinarily grateful, particularly to Shaleen, who's been hanging out with us and brought the topic here, and I will turn it over to her in just a minute to introduce the panelists and the discussion. But I kind of couldn't resist a chance not just to say thank you to her and everybody on our team to put this together and all the attendees, but especially to emphasize that this topic is in its own way kind of dear to my heart, because when I first proposed teaching, I think the first in the country marijuana seminar here at the Ohio State University Moritz College of Law, I had to convince my colleagues when they needed to approve the course that it wasn't just I wanted to seem cool with the students, but that there were actually a bunch of really hard and really important and really challenging legal issues that state level marijuana reforms were creating. And I think I did a good enough job convincing them because they let me teach the course. And I was so drawn to the topic and struck by how many issues there were that I thought needed a lot more attention and a lot more really thoughtful engagement that it largely led to the creation of the Drug Enforcement and Policy Center. And it's against that backdrop that an issue like residency restrictions and the constitutional and statutory and policy questions that it raises is exactly the kind of discussion that I was hoping a center like ours and folks like Shaleen would bring to this work. And so, against that backdrop, I'm just extraordinarily grateful for her energy and bringing on a terrific panel to talk about these issues. And at that point, I'll turn it over to Shaleen and let her get to the substance.
Thank you so much. I really want to thank the Drug Enforcement and Policy Center for hosting this. Holly and Yana and Doug have been so helpful in this. And if this is your first time at a DEPC event, make sure you check out all the fantastic resources that they have. Thanks everybody for coming. I want to start by briefly introducing myself and then letting my co-panelists, Richard and Shanel, introduce themselves. So my name is Shaleen Title. I'm a visiting expert with the Drug Enforcement and Policy Center. I'm also a co-founder of Parabola Center. And from 2017 to 2020, I served as a commissioner with the Massachusetts Cannabis Control Commission, particularly focused on social justice and equity issues. Richard?
Thank you, Shaleen. My name is Richard Juang. I'm also a co-founder of the Parabola Center. My thanks to the center for hosting us. I'm an attorney in practice in Massachusetts and the legal director of the center. I come to the table with a few years of experience working on cannabis issues, particularly around drafting the first set of regulations in Massachusetts and assisting Shaleen developing those regs. I've also had a hand in the Mass Minority Cannabis Business Association's first set of model state regs, state laws rather. And I come to the issue of cannabis not necessarily from being an advocate for drug reform, but as a civil rights and social justice advocate. The bulk of my experience is in LGBT, HIV, and civil rights. Shanel?
Thank you. Hey everyone, thank you so much for having us here today. My name is Shanel Lindsay, and I am the Entrepreneurship Director here at the Parabola Center. I'm an attorney here in Massachusetts. I've been practicing for about 15 years and about 7 years in the cannabis space. I was one of the authors of Question 4, a ballot initiative to legalize for adult use here in Massachusetts. And I was also a member of the advisory board for the first 4 years of our Massachusetts rollout. I'm also co-founder of Equitable Opportunities Now. We are a nonprofit that worked to ensure that there was equitable legislation and regulation post legalization here in Massachusetts.
Terrific, thank you. Really two of the most brilliant legal and strategic minds in this field, in my opinion. So thanks everybody for coming. The purpose of this event, just from the sky view of what we're talking about, is the question of when a state discriminates essentially against people from out of state, which raises constitutional concerns, but is very common in marijuana laws. Most cases today will be talking about when a state requires someone who owns or operates a business to be a resident. Many social equity programs also take residency into account. And every single state that has a marijuana market essentially bans out-of-state businesses from importing into the state. So it's a fundamental characteristic of legal marijuana as we have it today. And there are decisions that are happening in the courts and essentially dominoes that might be beginning to fall. And the bottom line is, if you care about fairness and equity, we don't have the luxury of ignoring this issue or leaving it to anybody else to take care of. And we have to understand it ourselves from that perspective. So the goal today is to demystify these cases in the most practical way possible. First, with the basic legal concepts and challenges, and then a summary of the lawsuits, where they are and what we might expect to see. And then finishing with the best practices that you can take away right now from the perspective of protecting marginalized communities and small businesses, as well as the policies that support them. So just to back up real quick about why we're holding an event on this topic, all three of us are from Massachusetts. What I witnessed definitely as the commissioner is how differently things go when people know about them, people who are impacted know about them and have the time and the access to digest this information and participate in the process. I just think of the two probably most significant equity related things that happen in Massachusetts. One being how local approval was handled, which was quick, kind of left up to lawyers, not talked about much initially until it was too late, versus our delivery program, which by design was decided in 2017 and only came into effect this year. And it was an actual participatory process where people understood it, gave a lot of suggestions that were put into place. And I think the results were, in the end, so much better when people were involved. And so that's why we're starting Parabola Center, to keep the power with the people and make sure everyone has the access to this information and the tools to be influential in policymaking rather than just a small select group. So at the end, we're going to quickly talk about federal language that could be in a bill that would actually make all of this potentially go away if there was authorization from Congress. But we're going to talk mostly about state level today. If you want to follow the rest of Parabola Center's work, you can see it at parabolacenter.com or at Parabola Center on Twitter and Instagram. So with that, I will turn it over to Shanel.
Great. And I don't know if we have our slide deck up, or maybe I'm not seeing it. Perfect. Great. I think we are on the next slide. Perfect. Thank you. So why are these cases important? As Shaleen mentioned, and Richard mentioned as well, equity is a cornerstone of the real, true legalization movement. And it's very important as legalization is actually taking shape and forms in states, that equity programs are at the forefront in order. And we've seen that real strong aggressive equity programs are really the only way to ensure that there's any kind of fairness or access, especially for communities that have been traditionally harmed by prohibition. And when we're crafting these equity programs, the goal there is to repair the harm to individuals and communities that have been decimated by the war on drugs. But the question becomes, how do we identify these communities? And there's a number of ways to identify communities, and a couple of ways would be by individuals' characteristics or their experiences, right? And examples of this would be, an example of a characteristic would be, a race requirement or component as an example, and an experience might be something like if somebody was arrested in the past or convicted, right? But in the case of prohibition and over enforcement, in addition to identifying populations by individual markers, there's also a history and opportunity of citing residents as a qualifier. And the idea there is that there's a specific intent of identifying locations where there's data showing that there's higher than average arrest rates or incarceration rates, because we understand and know that the generational effects of that incarceration and over enforcement is the harm that we are trying to correct. So when residence is used as a qualifier, often what that means is that people that are that meet those residency requirements, and often there's a durational requirement of how long folks have had to live there, or it could be potentially a blanket requirement of having to live in a certain area or state. They take different forms, but at the end of the day, if folks are able to meet these requirements, then often they're getting access to technical training, other things like priority review, or even exclusive access to licensing. And while residency requirements are often one of many different qualifiers for an equity program, they are definitely becoming the subject of increased scrutiny and litigation, because what we're seeing is that these larger MSOs and these savvy corporate operators are gaining national prestige and power, and they're definitely becoming more litigious in their quest to monopolize the industry and increase their market share. Next slide, please. So when we're talking about these residency requirements, it's important to understand at first what legal concepts are at issue. And what really comes up here, like in many of the legal discussions around cannabis law, are these very interesting and nuanced federalism issues, and primarily centering on the state's ability to provide preferences to members of one state to the exclusion of another. And as Shaleen mentioned before, this is not something that's new in cannabis. Frankly, almost all of cannabis law is something that is benefiting people within the state, right? Because of the illegality of the federal system. For example, medical programs often require residency to even access that program, right? And there might be limits on how much people can possess if they're out-of-state residents. So what is the specific argument here, right? What is the challenge when we're talking about residency when it comes to equity? As we probably all know, equity programs are often attacked on various different federal and state bases, like constitutionality is top of the list, whether we're talking about federal or states. And opponents of equity draw on any legal theory that they possibly can in order to try to knock out equity. What we've seen when it comes to residency is, and the cases that we're going to be discussing today, is the primary vehicle for lawsuits for residency are alleged violations of the Dormant Commerce Clause. And throughout our fight for equitable legislation here in Massachusetts, for the past 5 years, EON, Equitable Opportunities Now, has been working with Northeastern Law School on legal research related to these issues. And first, we focused on the need and mechanism by which to craft equity programs, and then looked at the various legal challenges and strategies that could arise there. And very early on, before we got into this deeper research with Ohio State and the Parabola Center, it was anticipated from the very beginning that the Dormant Commerce Clause was going to come into play here. And so just quickly on the next slide, going into just a brief overview, a refresher for anybody who hasn't been thinking and dreaming about the Dormant Commerce Clause for the last couple of years. The Dormant Commerce Clause states that state laws may be subject to challenge if they're placing unreasonable burdens on commerce such that they infringe upon interstate interests. Obviously, we are residents of states, but we are all citizens of the United States, or citizens of the United States are absolutely entitled to the benefits of living within our nation rather than just being privileges of their own state. And so it's incredibly important when we're talking about the Dormant Commerce Clause and residency requirements to understand that in theory, they are at odds with this idea that doesn't matter what state you belong to, that you are to enjoy all of those different benefits of being a member of our nation. And so when we're looking at the decisions on this topic from the Supreme Court, there's a 3-step analysis for what constitutes a violation of the Dormant Commerce Clause. And so the first piece of this is whether the state itself is acting as a regulator. And the second piece is whether the regulation is discriminatory against other states and members of other states, or merely incidental in the way that it's impacting interstate commerce. And then the third piece, if at step number 2, it is determined to be discriminatory, there is a way that the regulation could still be valid, but only if it is advancing a legitimate local purpose. And on its face, when the state is working to regulate private trade, it's likely going to be considered a market regulator. When we're talking about whether or not the law is discriminatory on its face, if it is discriminatory on its face, and that means that it is treating out-of-state residents different than in-state residents, then that's going to be a per se violation of the Dormant Commerce Clause. And you'll move into step 3, which is determining, even if there is a per se violation, there is a way for there to be an exception to the violation of the Dormant Commerce Clause if there is a legitimate state interest there. And there's also a third piece. If at number 2, you do not see that there is, if it's not discriminatory on its face, there's a balancing test. But in the case of residency requirements, it's usually very clear that there is a preference for in-state. And so you're looking at this usually traditional test. And so when we're talking about this last piece, because really in these cases, that's where we get to is, listen, is there a viable, legitimate local purpose there? We are looking at the highest level of scrutiny, strict scrutiny. And as we know from the constitutional standpoint, that's going to be a very high hurdle there. And when we're talking about durational residency requirements, and we're talking about marijuana generally, since cannabis is still illegal under federal law, we see it up until this point in case law, the burden really falling on the states to show that compelling state interest that merits a residency requirement. And the results largely depend not on just how strong a state, not just how strong of a case the state can make for the interest, but how well that interest is actually manifested in the regulations, because any disconnect there, as we'll see, can really prove fatal. And just before we move on to actually digging into the cases, as a larger practice point, it's often really helpful to remember that whether or not it's a challenge to residency requirements or race requirements, or whether the vehicle is the Dormant Commerce Clause or alleged violation of equal protection, really the main analysis always leads to really how tightly this exclusion is drafted and how much of a compelling state interest exists. And at the end of the day, it's almost that all roads lead down to these concepts. And as we discuss these recent nuances and discuss practice tips, really what we're doing is trying to create equity programs that are really built to last. And I will turn it over to Richard, and I think we're ready for the next slide as well.
Great. Thank you, Shanel. Again, my name is Richard Juang, and I'm the legal director of the Parabola Center. It's a real pleasure to be here. And in this part of the webinar, I'm going to give a quick overview of the key cases and identify some of the themes that are emerging in the litigation. And those are national themes. First, let's get a sense of the geography. If I may turn to the next slide. Great. On the screen, you should be seeing a map of the Federal Circuit Courts of Appeal. I've circled in green the states where residency restrictions have been challenged in federal court, and the restrictions have survived. In red, I've circled states where restrictions have been challenged and struck down. The little yellow circle you may see around Illinois is because a case that I think could have been quite important was brought, but there the plaintiff voluntarily withdrew the case, and so no decision was reached. It was not fully litigated. So when and how did these cases begin? Well, the fight over residency restrictions began on both coasts, first in Maine and then in Washington State. In Maine, Wellness Connection, a major player in Maine's medical cannabis sector, brought a case against Maine's state residency restriction. There, in an interesting turn, the state's attorney general conceded that there might be a substantial constitutional problem, the very constitutional problem that Shanel was pointing to earlier. Instead of fully litigating the case, the state of Maine and Wellness Connection entered into a settlement agreement whereby Maine would simply not enforce its residency restriction. This case was then voluntarily dismissed by the parties without prejudice. That's to say, the case could be brought again. But here's an interesting twist. The city of Portland, Maine, retained a residency restriction. Wellness Connection then again brought suit, this time against the city. That case against the city was in fact fully litigated. And the judge in that case struck down the residency restriction on the grounds that it violated the Dormant Commerce Clause. In other words, just to summarize, the restriction was an unconstitutional interference with interstate commerce. The state had overstepped its powers and was engaged in a form of excessive state economic protectionism. Now, on the other coast, we have a different story. A case, again, is brought in Washington State against the state residency restriction. Importantly, this case was first brought in state court by the plaintiff, an individual businessman living in Idaho. He challenged the Washington residency restriction on state constitutional and federal constitutional grounds. The distinction is important. The state of Washington, because of the federal issue, removed the case to federal court. And then the story takes a twist, another twist. The federal court declined to hear the case, citing what's known as Pullman abstention. This is a legal doctrine, and it's worth getting into. Abstention is when a federal court recognizes that while it does in fact have legal authority to hear a particular case, it has jurisdiction, it decides that it should not hear the case. This type of abstention, the type of abstention that was used in Washington State is called Pullman abstention, and it arises when there are important issues of state constitutional law and state sovereignty at stake in a case, and a federal court recognizes that it should not really be the first entity to step in and set a legal precedent. In other words, the state should have the first bite at the apple. So what happened in Washington? The federal district court recognized that, yes, there were in fact complex issues about state constitutional law and state policy being raised, and that those issues should be litigated first in state court before reaching the federal issues. In other words, if a decision could be reached at the state level, then there was likely no need for federal interference into essentially a matter of state sovereignty. Again, states should get the first bite at the apple. The district court sent the case back to Washington Superior Court, where after some time, the residency restriction was upheld. So you have these storms brewing on both coasts, and they meet in the middle of the country. Right after Washington State, cases come up in quick succession across 2020 and 2021 in Oklahoma, Missouri, and Michigan. In Oklahoma, the restriction, the residency restriction is left in place. The district court there says very bluntly that commerce in cannabis is illegal, and it will not, therefore, exercise its powers to facilitate an illegal commerce. In Missouri, the court reaches a different decision. The state residency restriction is struck down on Commerce Clause grounds. In Detroit, a local residency restriction is similarly struck down on Commerce Clause grounds. So this now brings us up to date and up to Maine. In Maine, Wellness Connection has once again brought suit. Remember, previously, the case was dismissed without prejudice. Here, Wellness now seeks to permanently strike down the state residency restriction. This time, however, the state is not conceding. It is defending the residency restriction. And importantly, it can do so because the prior case was not fully litigated. So it's not stuck. It's not bound by its own position previously. In this renewed case, not surprisingly, however, the judge has in fact struck down the state residency restriction. This is consistent with her prior decision in the Portland case. And she has once again found that the state residency restriction violates the Commerce Clause. But another interesting piece of the story has come up. The judge has stayed her order pending appeal, meaning that she is suspending the enforcement of her order, striking down the residency restrictions until the First Circuit Court of Appeals can reach a decision. And she did so on two very important grounds. First, she recognized that this is in fact a novel issue where the circumstances don't fit neatly into a traditional Commerce Clause case. A traditional case would be one where a state simply tries to close its borders to legitimate interstate commerce without permission from Congress. Congress has not authorized it, but the state oversteps and tries to regulate interstate commerce. It's not the same kind of case because of the federal illegality. She has also recognized that if she does not stay her own order, it could result in an inconsistent licensing and regulatory scheme for the state of Maine. So if she allows her own order to move forward, and some companies get licensed without residency restrictions, and then the First Circuit later reverses her decision and puts residency restrictions back into place, then you might have some companies licensed without residency restrictions, some companies licensed with residency restrictions, and this would complicate an already extremely complicated legal situation. What's important here is to notice that she recognizes that there is a meaningful risk that her decision can in fact be reversed by the First Circuit. So let's step back to the overview again, to our map. I think we see two themes emerging. One, those courts that draw a straight line between the Commerce Clause and residency restrictions tend to strike down residency restrictions. They are seen as simply an improper overstep by the state. Where courts take a more cautious approach to state authority and state sovereignty, recognizing the unique context of state legality and federal illegality, residency restrictions seem to have a chance of being upheld. So the fight is by no means over, and I think we're going to see a really strong fight between state sovereignty and state authority and the Commerce Clause. Furthermore, if we look again at the map, we should be aware that there's a significant chance of a circuit court split. If the First Circuit strikes down residency restrictions, it's likely that the 10th Circuit will have a different outcome, and possibly the 9th Circuit. If the First Circuit upholds residency restrictions, reversing the district court, then the 8th Circuit and 6th Circuits will come into play. What this means, bottom line, is that a Supreme Court case is likely, it seems to me, in order to resolve a future circuit split. So what does this mean for those working, for those of us working on cannabis issues? First, I think it means our timeline for action goes well beyond this First Circuit decision. We have to be looking ahead past the First Circuit to a possible Supreme Court challenge. Secondly, we should be aware that even though courts don't typically respond well to direct public pressure, they are also quite aware when a set of laws or policy choices by states have a great deal of social consensus behind them, that there's social and political legitimacy and a lot of economic expectations build up around a set of policy choices. So as these decisions are going through the courts, I think it's essential for us working in the sector to be making visible that sense of legitimacy to these state. We need to be making visible the legitimacy of these state regulatory schemes, that they're there to protect people, not just protect special interests. As a practical step, it may be important for states' attorneys generals to be pressured to voice support for residency restrictions in their states, and to voice support for the regulatory structures of their states more generally. A strong consensus among state governments can in fact have a strong effect on the federal judiciary. So bottom line, it's important to know, it's important for courts to know why those policies are in place and that they have the support of state government. And of course, finally, if Congress passes a law expressly permitting state residency requirements in cannabis, then all of this is clarified, and there's no need for further litigation. Or at least hopefully there's no need for further litigation. So thank you. I'm going to pause here and turn this over to Shaleen.
Thank you. You both took a lot of information and made it digestible and boiled it down. I'm going to encourage people to submit questions if you have them. I don't know if we'll get to them, but we are planning to do a lot of work on this issue. As you can see, it's very active and very significant. So at the very least, we'll use the questions for the future. So the next slide will introduce the next part, which is considerations and best practices to take away. The first thing I want to emphasize is that everybody has a role in the creation and the revision of these policies, of state level marijuana policies in particular. I think that, you know, when I talk about best practices, of course, it's going to make sense that, you know, for regulators and lawyers, there's a direct role. But people who are impacted by the policies, if you're here, first of all, I'm really glad that you're here. And second of all, what you say really matters. What you experience, the original ideas and innovations that you have for how this can move forward. And if you are speaking out about your experience, you could very likely shape these policies, especially at this point, you know, where there's not that much discussion about it. So I'm glad that all of you are here and getting educated on this, and I'm sure coming up with your own ideas as well. The second thing I want to underscore is that, as you can see, there are a lot of different ways that this could go. Even just between us three attorneys, I'm sure we could come up with, a million different scenarios, and we're not trying to have a 5-hour webinar, to address everything. Instead, the best practices that we'll go through are good policymaking and citizen engagement practices that will only be helpful regardless of which way the lawsuits go. So we tried to just limit it to those practices. So to start, let's talk about documentation. I think that's the most important thing. Shanel mentioned this earlier. We start with documenting the basis for any and all licensing and social equity rules that benefit residents, starting with very clear goals. And again, there are two parts to this process. There's the actual analysis, and then there is the documenting and communicating of it, which I think are both equally important. If you are a nonprofit, if you're a social equity business, if you have any kind of stake, if you're a law professor, and you are out there talking about this, summarizing what you're seeing, doing your own analysis, that is very helpful. So you start with your goals. Who are you trying to benefit and why? If you are simply trying to benefit your own local residents for protectionist reasons, that might be risky in light of all the cases we've just discussed. If you are trying to benefit people who have been disproportionately harmed by the drug war, which is the most common social equity program goal, how do you define who that is? And most states with social equity programs have some kind of impact study to address that question that looks at arrest and incarceration data, perhaps other data that addresses how a community has been harmed, like income, poverty, unemployment. In Massachusetts, we did two, one at the municipal level, looking at all cities and towns, and then one that broke down the biggest cities into smaller areas. In some places, it's zip codes, some places police beats, some cases census tracts, but you're trying to be more narrow in that case. And then also updating them, because it's not going to stay static forever. So after a few years, you probably want to redo your data. You could also consider using cannabis industry specific data, which we don't see that much yet, but now it's been 5 years since the first equity programs were put into place. We have a ton of data. In Massachusetts, we have data on disproportionately harmed people and their involvement in the industry, and then every demographic, that's all been broken down. And so if you're building a program, you can make potentially an apples to apples case where you say, look at how the industry currently looks, and here's the data, and that's the problem that we're trying to address, and here's how. I think, it might be different in every area, what your goal is and how you're trying to identify them, but the key is that you really document that analysis and you're not just choosing kind of random factors, or even just because another state did it. You should be able to document the basis yourself. Okay, so next, best practice is to consider whether your goals can be accomplished without residency requirements. And this is a good practice because you may find that you can, in fact, reach your goal without them, which could make your policy stronger and less susceptible to challenges. Again, we talked about poverty, income, unemployment. You could also look directly at drug convictions or a family member with a drug conviction. And you could say, it doesn't matter, whether you're a resident or not. If you have a drug conviction, you're considered to have been affected by the drug war. Potentially, you could look at other cities and states' social equity program criteria. You could say it doesn't matter if you qualify in this state or if you qualify in another state, you are considered to be someone who has been disproportionately harmed. Therefore, you're part of the community that we're trying to reach. In other words, there's nothing magical about these residency structures that were first originally developed in parts of California, Oakland and Los Angeles, and then Massachusetts was the first state to use them At the time, it made sense. It still kind of makes sense, but it's not the only way that you can identify communities that have been disproportionately harmed, especially now that we have more data, we have more lead time. It's something that you can certainly think about and craft your own research to identify. And then this is also a very good practice, because if you find that you have weighed the alternatives and you still think that the best way to get to your goal, your clear goal that you have identified, is through residency requirements, now you've documented that. And so that analysis will only help you should a court look at your program and decide whether it meets a certain standard. So next, let's look at an example. You want to stay aware of the strict scrutiny standard of having a policy that is narrowly tailored to a legitimate local purpose. So I am not commenting on what will or will not meet that standard, but regardless, it is a best practice to stay aware of it. And you'll only help yourself if you think through this analysis when you're creating a program that benefits residents, and especially a social equity program. So for example, in the Detroit case, a federal judge found that reserving 50% of marijuana licenses for people who have lived in Detroit for more than 10 years was irrational and did not advance the stated goal of assisting those who had been harmed by the war on drugs. So there wasn't really a challenge in the decision as to whether assisting those who had been harmed by the war on drugs was a legitimate local purpose. Let's assume that it is. Let's assume that you can show that with the piles and piles of universal data from across the country showing that the drug war has not been fairly enforced, and that it's the government that's responsible for that. Then the next question is a requirement that in order to benefit from the program, someone has to have lived in Detroit for over 10 years. Is it causally connected to that goal? So the court rightfully asked, what about someone who lives in the next town over, who has a drug conviction that has affected their lives, that doesn't qualify, and then a person who has lived in Detroit but doesn't have a drug conviction, or hasn't shown in another way that they were affected, does qualify? Does that make sense, and is that rational? They said no. So take that into account. And if you do want to have a residency requirement, I think the takeaway is you can think about ways to make it so that it's not overbroad. So for example, can you qualify in a different way if you're not a resident? Can you perhaps divide up a big city into smaller areas so you have more evidence for each area that you're targeting? You can think through the number of years. If it's 10 years, do you have evidence to show that that's the right amount of time, that someone should have to have been a resident for that long? Or are you just making it an overbroad requirement? And then again, it's really important not just to do the analysis, but to communicate these things, making sure that it's easy for anyone to find and that it can be updated later. Next, let's talk about learning, upholding, and referring to the priorities of the Cole Memorandum, especially preventing diversion. So I wanted to put this in from the perspective of looking forward, thinking about the fact that courts are very likely going to be weighing different goals and priorities, and perhaps the federal priority of not discriminating against various residents versus other federal priorities like what's listed in the Cole Memo. So as a refresher, the Cole Memo is from 2013, technically has been rescinded, but is still notable, and indicated that the federal government would not prosecute state legal businesses as long as certain priorities were followed. And one of those priorities was implementing effective measures to prevent diversion of marijuana outside of the regulated system and to other states. So if you are implementing that type of effective measure, make sure that you document it as such, and you don't end up in a situation where someone could be looking at it and thinking that it's or making a case that it's simply protectionist without having other documented rational purposes. Okay, so next, thinking ahead. So obviously we're in a place here where we don't know what's going to happen in the First Circuit. We don't know what's going to happen in all of these different states. And we certainly don't know what's going to take place in each state, especially if you have residency and social equity programs. But one thing that I have learned from watching a lot of things play out is that when you have uncertainty and when you have what I would describe as chaos and confusion, it's always the more well-resourced groups that tend to do better. And it's the smaller businesses, social equity, and marginalized people. Things don't tend to go as well unless you prepare and think about it in advance. So that's why at this point, you should be thinking about how to minimize disruptions to social equity programs by considering various alternatives that we've discussed. And, if you're a regulator or a policymaker, I suggest just thinking about the concept of severability and what a program might look like to move forward without residency requirements. If you're a law student or aspiring policy expert or cannabis lawyer, this might be a way to differentiate yourself and enter the conversation by looking at your local rules. And starting to put out there what the alternatives could potentially be. I have definitely already heard some rumblings, you might have as well, that these cases could potentially end social equity programs with the assumption that you can't have social equity programs at all without residency requirements. That is not true. And I think that the more we talk about that and have public, transparent, ongoing discussions about it, the less likely it is that an idea like that will take hold. So we're coming to the end here. I want to end on a especially optimistic note. Well-written, on the next slide, you can see well-written federal legislation could potentially make all of these problems go away by explicitly authorizing states to continue these rules, but it has to be explicit. It has to be unmistakably clear. So a court will not infer from legislation that Congress has meant to give states the authority for this kind of discrimination, this kind of protectionism, unless it's absolutely clear. And so there are various models that have been floated for what that might look like. Parabola Center has a few that are based on different constitutional scholars' theories that we've built upon. There's an idea that you could just have Congress explicitly delay or turn off the Dormant Commerce Clause for a certain period of time. That might potentially just freeze things the way they are. That may or may not be a good idea, but you could do more. Congress could potentially turn off the Dormant Commerce Clause or give protection to certain states if they're doing it as part of a social or racial justice effort or a social equity program. There's a lot of different ways it could go. And I do want to note that as they read currently, the MORE Act, the Cannabis Administration and Opportunity Act, and the new States Reform Act, none of them have this kind of explicit, unmistakably clear authority for states to continue what they're doing, which is potentially a huge problem and possibly not one that was anticipated, I think, by the authors. So I would suggest if you want to stay in this conversation, that you speak up at the state level right now, review your program, make sure it's documented, and then at the federal level as well, make sure you're in touch with your representatives, and that you're talking about what you want to see, what your experience has been, and that they know that if they want to preserve anything about the state programs as they are now, the best way to do that is to make that unmistakably clear in any bill that gets considered. So I think our last slide is just suggesting that you speak out and you educate others about the solutions that protect local and disadvantaged communities, and that we keep that at top of mind. Do any of my co-panelists want to make a closing statement? While I look at the questions.
I think your focus on, just quickly, I think your focus on the best practices when actually crafting equity regulations is really spot on, and that it really does require the work at the outset to create the kind of record that you're going to need in order to defend going forward. If there isn't a template for these things, and as we see with many different constitutional issues, it really does come down to how well that intent can be manifested, and how well that how narrowly tailored these things are. And I think that when states and regulators or advocates or activists are looking, everybody's always looking to what somebody else has done, but it's really important to understand that we're all still creating and building this here, and really going back to the basics and fundamentals of doing the groundwork is, I think, incredibly important.
Coming from a civil rights and economic and social justice perspective, to these issues, I find that it's really important to bring to the foreground issues of legal and cultural and social history. What I mean by that is that judges need to recognize that these issues, the cannabis sector more generally, arose as a matter of developing state laws and policies for equity in the face of 20 years of congressional silence. Congress knows that these marketplaces exist, knows about these equity programs, and has not done anything to stop them. So that silence, I think, speaks volumes to the legitimacy of cannabis equity solutions and of state cannabis equity programs and laws and policies. So I think making visible both that these marketplaces have a long history and have a history that is often centered about equity is critical, because judges should not be making these decisions in a vacuum where it's simply, here's a past precedent, let's just apply it willy-nilly to this new situation. So history, context, and a fundamental sense of justice are all really important to foreground when discussing these issues.
Thank you. We have a few minutes left, so I'm going to take one of the questions, and then I invite both of you to review if there's any that you want to answer. But someone asked, Jacqueline Patterson asked, do you know anyone who is doing any work regarding equity, justice, and disability? I do not. I'll highlight it in case anyone wants to highlight another group. But it does bring to mind a question that comes up often in these discussions, which is how we identify people who have been disproportionately harmed versus, I think, really important marginalized, harmed groups in general that should be included, but we may not have specific data that shows that they've been affected by drug convictions in particular. So I think it's really important to keep both of those in mind. I can say in Massachusetts, we have different policies where if you have been disproportionately harmed based on either the residency for us or a drug conviction or a family member with the drug conviction, you qualify for certain things. But then we also have robust, and I think this is becoming more common in plenty of states, advantages for minority-owned businesses. And the difference there, by the way, is that, at least according to our research in this state, you could be an Asian-owned business, potentially qualify as minority-owned, but then not be considered disproportionately harmed because we don't have any evidence that Asian people have been disproportionately targeted by the drug war. So we've got minority-owned businesses, women-owned businesses, veteran-owned businesses, and many more groups where we require businesses to show their diversity plans. I know in New York, there's various benefits that are being contemplated for those groups. So I think it's very important to be clear about your goals in all of those policies, and not to conflate the idea of disproportionately harmed communities getting certain benefits with things that are not necessarily supported by evidence, even though they're just as important. So I hope that makes sense. Anybody want to address any other questions?
There are some questions about legislative priorities documents. So I think that we did share the comments, or maybe we just want to call that out again, on federal legalization. And also, I'm sure that there will be much more forthcoming when it comes to Parabola Center and guidance there, but I noticed that as well. And then there was also a question, sorry, I'm going through here, about strict scrutiny and the Dormant Commerce Clause and why it's subject to strict scrutiny, and just wanted to circle back around to those foundational concepts of Dormant Commerce Clause being something that is very controversial just generally. It is not something that's actually listed in the Constitution. It is a legal theory that has been created, and there are actually many members of the Supreme Court who don't really believe in the Dormant Commerce Clause. When it comes to the strict scrutiny aspect, that is for things that are on their face discriminatory. And that is the standard there, meaning that if you're saying, hey, we are protecting somebody within this state and discriminating against somebody out of state, that on its face is protectionist, and that's why you're having that higher level of scrutiny. There are some Dormant Commerce Clause cases where there is, it is not on its face discriminatory, and then there is a different level of scrutiny there with a balancing test for those who are interested.
Thank you. I could take the one where someone asked, under a federal legal interstate commerce regime where one could get a license anywhere and sell nationally, do you still think the residency requirements are as important? I would say, I think that's really up to the people in that state, but I know that residency requirements are very popular. I know it was one of the most popular policies that we considered. And I know there was just some research that came out of adults who were surveyed in New Jersey that was put out by RTI. We just did an interview with the author that you can find on Parabola Center's social media. But essentially what they found was that the majority of people wanted to see an equitable rollout. And then when they asked them what an equitable rollout means, they were very open-minded. But of the people who had an opinion, for them, state residents, it was most important that they be prioritized. So I think to people, it's important, but of course it has to be specifically authorized by Congress, or else, they'll just be invalidated. I also want to point out that sometimes when I have this conversation and people talk about opening up the market, they're picturing, I think, a more perhaps equitable situation than we currently have, because likely these inequitable systems that we have in every state would continue. When we're talking about capital requirements and security requirements and all of that, of course, parts of it would be easier after federal legalization, but in general, those requirements would continue, but you would have a free-for-all where instead of just competing with everybody in your state, you're now competing with everyone. So it's not necessarily an open market in the sense that it's, free and you have open competition. Right, we have 1 more minute. Does anyone else have anything they want to say? Okay, then we will close it there. Thank you so much for coming, and thanks again to the Drug Enforcement and Policy Center for hosting us.
It has been an honor and pleasure to be part of this panel. Thank you again so much to the center. Thank you to all the participants.
Thanks, everyone.